just a sneak peek of the lifetime with the lady that I did a previous video to of lifetime of, geez, I'm leaving it blank. Protection order for the lifetime.
Proceeding would be under subsection L, and that relates to a conviction. Whether or not there are other grounds that could have been alleged, there might be. There are, I believe, 25 different grounds for involuntary termination of parental rights. But in a termination proceeding, that is a whole different ballgame from what happened here. Usually those cases are going to take 12 to 18 months. You're going to do discovery. You're going to have an opportunity to put on a complete defense. Your criminal case, most people, or many people who have a protective order, have a criminal case pending in those 14 to 20 days when they have to have a hearing.
Isn't your argument really protecting the parent over the rights of the child not to be harmed?
No, Your Honor, there has to be a balancing act here. And there are other constitutional mechanisms for protecting children and other victims of domestic violence without this statute. A lifetime protective order is not necessary to protect children from imminent danger. We have temporary protective orders. We have injunctions and SAPSA proceedings, bond conditions if someone is under criminal indictment. There are a lot of constitutionally tested processes that could have been used in this case, and could be used in this case if this court vacates the protective order, if it is appropriate, which I do not believe the facts support that. But I realize this court must look at precedent for all protective order cases, and you will have a concern for the safety of victims, as we all do. That does not negate the constitutional rights of parents, and they must be protected. I see that my time is up.
Any other questions? Thank you, Ms. Draper. Ms. Guzman, we'll hear from you.
Good morning, Mr. Chief Justice, and may it please the court. Termination of parental rights has been described as the death penalty of civil cases. And that description fits because what's at stake is the fundamental liberty interest in the care and the custody and the control of our children. The lifetime protective order here raises serious and critical constitutional questions because it effectively terminated parental rights without the safeguards of a termination proceeding. One is not a substitute for the other.
Even if, I wonder if it's even worse than termination, because if your rights are terminated in a conventional parental termination proceeding, your legal right to the children is extinguished, but you can still write them a letter. Or say hello to them at the grocery store, or which she can't even do that.
Let's make no mistake, and that's exactly right, Justice Blacklock. This order is permanent and it's forever. And Justice Ferris noted in her dissent that this is worse than a termination order because even when these children turn 18,
this is a key point.
They can't see their mother if they want to because their mother may face criminal prosecution. A parent's fundamental liberty interest in her children doesn't vanish when she faces serious allegations of abuse and investigation, or even when those familial bonds are weakened.
Well, there was more than allegations of abuse here. She was indicted for injury to a child, and there was testimony that the trial court believed, and it had to believe in making a finding that a felony had occurred. So if we agree with you that there's a higher evidentiary standard that should apply because of the rights that are at stake, what do we do for purposes of resolving this case? Should it be remanded to the trial court for a new trial? Should an appellate court endeavor to review the record under a clear and convincing evidence standard and determine if there's enough evidence to meet that standard? What should we do?
This court should remand this case after it reviews the record and is convinced, assuming the court adopts the clear and convincing standard, that this trial court formed a firm conviction and belief in the allegations She didn't allow an offer of proof. She limited cross-examination. She didn't allow a witness to testify about Mr. Etheridge's own violence. That goes to credibility. The question here is not whether a lifetime protective order is ever available in any case. Certainly in the boyfriend dating relationships, those are available. They shouldn't be subject to the same scrutiny. But the parent-child relationship, that's fundamental. The question here is, what process is a parent entitled to before there is a deprivation of parental rights? Whether it's through a termination order, as it should be. If it's that bad, they have a constitutional option. Instead of a lifetime protective order, go file a termination. That's a constitutionally tested process. As the majority said in Santosky versus Kramer, it can't be that to terminate parental rights or to effectively terminate them, as Justice Ferris noted in her dissent, the standard is the same as for awarding money damages.
Would the constitutional issue be, or analysis be different if this order, instead of saying permanent duration, said duration of 10 years?
The question for me is there a permanent deprivation of parental rights?
10 years wouldn't be permanent, so you would concede that there's not a constitutional due process violation if it was 10 years?
No, I don't concede that, Justice Boyd. A firm conviction or belief. 10 years, if all the stars align in those 10 years, I may get my rights back. I don't think this idea that you can modify, if that's where we're going with this, is sufficient to cure the initial constitutional deficiency.
I'm trying to figure out what I'm hearing from the petitioner side here is because it's permanent, you have to have extra protections constitutionally. And of course, then but 2 years you don't. And now you're going to get into that spectrum. Okay, what about 10 years? What about 9.5 years? What about 9 years? When does it become constitutionally significant?
This is a due process question. What process is a parent entitled to? A temporary order doesn't raise the same constitutional concerns. A 10-year order does. So it's not temporal. It's what is the deprivation? If the deprivation is you can't see your children for 10 years, you can't go within 100 feet of them, you can't communicate them, you can't communicate with them, there is a counselor somewhere out there that's going to decide whether in that 10-year period, that's a lifetime for a child.
But if it's only 2 years, then it's not a constitutional problem.
I believe anytime you're dealing with a fundamental right,
so 2 months would be a constitutional problem.
there are constitutional avenues for these 2-month periods or these two-year periods. They are temporary injunctions. They're issued all the time in family law cases. There are restraining orders that can be issued temporarily for the 2 months until there's an opportunity to assess and evaluate whether this deprivation impacts the fundamental right to care, custody, and control. That's what's at issue here. In a termination, there are service plans that you sometimes go through before your rights.
All right, it's just a little taste of what's going on. I did a previous video of this case with a lady, trying to follow judicial complaints on a judge that they are ignoring, and talked about how this case was going to be brought up today, and in fact, it is now live. This is the problem we have in family courts. There is no due process. Regardless what anybody says, there's no due process in family courts. And if there is, it's very little and very minimum. And these courts right here, and I'm not an attorney, not giving legal advice, just my opinion, from my education only, okay? They're even ignoring the criminal codes 14, 15, and 16 here in Texas. So to put the full faith and credit in the judicial branch is hard for me to swallow due to I read the criminal codes and I know that they are ignoring it. So for this woman to actually get due process when the courts are ignoring the due process and following the law in Texas is already an issue on hand, on face, in law, in writing. This will be the People News. Bye, y'all.